Okay, picture this. One dental group recently got hit with a $95 million lawsuit, all over recorded calls. Yeah, 95 million. That is a staggering number, right? And it's exactly why we need to talk about the hidden risks in the software you might literally be using right now. One wrong setting, one missing contract, and the convenience of modern technology can turn into a massive legal nightmare.
Welcome to this explainer. Today, we're asking the million-dollar, or, well, the $95 million question. Is your new dental AI actually putting your practice at a massive regulatory risk? Dental practices handle protected health information every single day. And with AI voice agents, virtual receptionists, and automated patient communications becoming the new standard, we really need to make sure your compliance is just as sharp as your technology.
Here's our roadmap for today. First, the AI compliance trap. Second, unmasking PHI and BAAs. Third, the call recording risk. Fourth, debunking the HIPAA-certified myth. And finally, the safe AI checklist. Let's dive right in.
Part 1. The AI compliance trap, where convenience meets privacy.
Look, we all know AI voice agents are incredibly convenient for front desk teams, right? They handle overflow, they book appointments, they send follow-ups. But here's the catch. That convenience absolutely cannot come at the cost of patient privacy. Now, before we go down this rabbit hole, I want to be crystal clear. This explainer is educational, not legal advice. HIPAA enforcement really turns on your specific setup, your state laws, and rules that are actively changing as we move through 2026. So definitely use this as a starting point to chat with a qualified healthcare compliance attorney or your compliance officer.
Just to put the financial stakes into perspective, take a look at the 2026 HIPAA civil penalty tiers. If you make a mistake simply out of a lack of knowledge, penalties start around $141 per violation. But, and this is a huge but, if it's uncorrected willful neglect, you're looking at over $71,000 per violation. And worse, that compounds. Willful neglect can literally cost over $70,000 a day, capping out at roughly $2.19 million annually. So the cost of doing it right is basically nothing compared to the cost of getting it wrong.
All right, moving on to Part 2, unmasking PHI and BAAs. Let's look at what data is at stake and what contract actually protects you.
To protect your practice, you've got to know exactly what data is on the line the second a virtual receptionist picks up the phone. Let's talk about PHI, or protected health information. In plain English, PHI is basically any health information that can identify a patient. Under HIPAA, there are 18 specific identifier types. It's not just a medical chart in a filing cabinet, it's literally anything that links a person's identity to their healthcare during a routine phone call. And it's kind of mind-blowing how fast those identifiers stack up. Think about a standard 90-second scheduling call. Your AI agent is grabbing the patient's name, their phone number, the reason they're calling, maybe their treatment history, their insurance ID, all of it. And on top of that, the call recordings and the AI-generated transcripts instantly become protected health information too. That is a massive amount of PHI captured all at once.
So if your fancy new AI tool is chewing through all this sensitive data, how do you actually protect it? Well, the magic word here is a business associate agreement, or a BAA. This is the totally non-negotiable contract that lets a vendor legally handle PHI on your behalf. If an AI vendor creates, receives, maintains, or transmits PHI for you, having a signed BAA is absolutely mandatory. No exceptions. Before a single piece of data is shared, you need this signed. If a vendor pushes back or won't sign one, run the other way. That is a massive red flag.
Now, what a BAA essentially does is create a strict division of duties. Your practice is what's called the covered entity. That means you get the BAA, you train your staff, you handle patient consent, and ultimately, you stay liable. The AI vendor is the business associate. Their job is to sign the agreement, encrypt the PHI, maintain audit logs, and report any breaches to you. So yes, a BAA provides legal protection, but don't think of it as a get-out-of-jail-free card. You can't just hand off all accountability. You are still the boss of your patient's data.
Okay, on to Part 3. The call recording risk. Let's talk about the sharp-edge risk of voice data.
Call recording is honestly where practices really tend to get hurt. Why? Because the actual voice recording of the call is itself considered protected health information. Now, federal HIPAA governs how you protect those recordings, but state law decides if you're even allowed to record in the first place. In commonly cited two-party consent states, places like California, Florida, Illinois, and Pennsylvania,
Every single party on the line has to consent before the recording starts. The easiest, safest fix here, just add a recording disclosure right at the very beginning of every AI call. Something simple like, this call may be recorded for quality and scheduling purposes. Capture that consent before any PHI is even discussed.
So how to practice is actually fall into the recording trap? Usually it's one of 4 ways. First, recording calls without that clear consent disclosure we just mentioned. Second, storing those audio files in some random non-HIPAA compliant software. Third, sharing those recordings with vendors without a BAA. And fourth, and this is a super sneaky one for 2026, letting a vendor use your patient's actual call recordings to train their own massive AI models without getting explicit consent. You absolutely have to watch out for that.
Which brings us to part 4, the HIPAA-certified myth, or why official badges just don't exist.
Now that we're clear on the risks, let's bust one of the most dangerous and widespread myths in the dental software world right now. If you only remember one thing from this entire explainer, let it be this. There is literally no such thing as a HIPAA-certified product. I'm serious. If a vendor pitches you and points to some shiny little HIPAA-certified badge on their website to prove you're totally safe, you should be extremely skeptical. True compliance isn't a sticker you can just buy. It comes from active, continuous safeguards, things like encryption and audit logs, plus, of course, that signed business associate agreement.
And hey, speaking of compliance, you might have heard some chatter lately about HIPAA getting way stricter this year. Let me clear that up. The 2026 HIPAA Security Rule Update, published by the Office for Civil Rights, is right now just a proposed rule, an NPRM. It is not final law yet. So, while it's great to know that things like mandatory multi-factor authentication are probably coming down the pipeline, your immediate focus really needs to be on actively complying with the current enforcement rules right now.
Finally, Part 5, the Safe AI Checklist. Let's de-risk your AI adoption.
I really want to leave you with a practical, actionable way to evaluate all this new tech. So when you're out there shopping for a dental AI vendor, use this rapid-fire checklist. Ready? Number 1, will you sign a BAA before we share any PHI? Number 2, is our patient data strictly encrypted both in transit and at rest? Number 3, do you ever use our PHI to train your AI models? Number 4, how is state consent handled and what are your retention policies? And finally, what's the breach notification window, and is there a clear human escalation process if the AI gets confused? Accept nothing less than crystal clear answers to these.
So, what does it look like when it all comes together perfectly? Well, here is what good looks like. Step 1. A patient calls, and the AI answers, entirely covered under a signed BAA. Step 2. The call recording rules are properly disclosed right up front, so consent is captured. Step 3. The AI creates a beautifully encrypted summary that only hits your approved secure systems. And Step 4. Data access is strictly limited to just the necessary staff. When you set it up like this, incredible convenience and rock-solid patient privacy coexist beautifully.
So I want to leave you with this one slightly provocative question. Is your dental AI ready? Think about the tools you're currently using at the front desk or the software you might be demoing this week. Do they actually pass the test? Are they a helpful convenience, or are they a hidden $95 million risk waiting to happen?
Look, it's absolutely possible to use incredible, cutting-edge AI tools while keeping your patients completely safe. You just have to ask the right questions. To help you do exactly that, I highly encourage you to read the full blog and download our comprehensive HIPAA vendor question checklist. Print it out, take it with you to your next vendor meeting, and protect your practice today. Thanks so much for joining me for this explainer. Keep learning, keep asking those tough questions, and I'll catch you next time.